Good morning, everybody, and welcome to this next instalment of the 3PB brunch seminars. I hope you're all settled in with your smashed avocado and soy latte, or instant coffee, as it's probably more likely to be. I recognise that. To kick things off, Luke Nelson is going to be talking to you about the FRC Efficiency Statement. You have 20 seconds to comply. Those of you who didn't get the RoboCop reference will need to revisit your 80s movies. I'm then going to take you on a whistle-stop tour, I suppose, of enforcement proceedings and financial remedies. There'll be time for questions at the end, so I know you're all bursting to ask lots of questions, so please put those in the Q&A box. And just to let everyone know as well that our slides will be circulated to participants after the event. So no need to take copious notes unless you particularly want to. So at this point, I'm going to hand over to Luke and put myself on mute for a moment.
Good morning, everyone, and thank you, Sam, for the kind introduction. And in case anyone hasn't yet been sufficiently smashed over the head with the reference, here is what you will all be pleased to know is that the final RoboCop reference in the very first slide. So yes, today we're talking about the FRC Efficiency Statement. Before I begin, I just want to proffer apologies for my hoarseness. I'm currently recovering from a bout of COVID, but COVID being obviously inefficient, it would be very against the topic of this talk for me to slow down. So here we go. I'm going to address 4 points today. As we can see on the screen, what is the efficiency statement? What's new? What are the consequences of failure to comply with it? And has it rolled out successfully? So then, what is the efficiency statement? It started off, some of you will recall a few years ago under Sir James Mumby, it was declared that the Financial Remedies Court was being set up with the aim of making a more efficient and coercive system of financial remedies. It was accepted at that point, and it would take a few years for the procedures to bed in. Those few years, as we're starting to see from the case law of slack, let's say, for practitioners, seem to be coming to an end. Now, the efficiency statement, it's fair to say it is guidance. It's supplemental to the practice directions and family procedure rules that we know and love, but it is more increasingly referenced by senior judiciary and understood to be best practice all round for financial remedies practitioners. And as we're starting to see from some case law, one of which I'll refer to later, the courts are getting increasingly stern with enforcement of compliance. If you can summarize the efficiency statement in, 3 statements, those would be statements 3, 4, and 5 on the screen: more front loading, more efficiency, more collaboration. Now, query whether front loading and collaboration should go first, followed by efficiency, because efficiency supposedly follows those two. That's where we are. More work needs to be done at the start of cases. That work necessarily involves more communication between solicitors earlier on, and that it is hoped, and we have seen from some anecdotal experience, to some extent successfully, increasing efficiency in financial remedies matters. So then what's new? Well, I think the first answer to that is a lot. Given the limitations of this talk, will keep it fairly brief. Suffice it to say that if you do practice financial remedies, and presumably everybody here does, otherwise why would you be here? It bears reading in full, the efficiency statement. If you struggle, or like me and Sam are very, very busy day to day, then you can refer to my handy article, shameless self-promotion there, which will be distributed after this. So 3 standard documents: there's the allocation questionnaire, the ES1 case summary, and the ES2 schedule of assets. I won't touch on the allocation questionnaire today, primarily because as a barrister, I've never seen one in action. Things tend to get to me after that stage. So I have no shame in holding my hands up and saying that some of these participants will probably know far better than me. The ES1 and ES2, though, by this point are now good friends of mine, and I will discuss them in some detail. The efficiency statement also sets down best practice for each stage of proceedings. In short, what you can expect at any stage is an increased requirement to agree documents. The ES1 and ES2 go some way to improving that rather. Before every hearing, there needs to be an ES1 and ES2 updated if necessary between FDA, FDR and final hearing. And if at any stage a hearing is intended to be utilised to negotiate, i.e. an FDA to FDR, the parties are expected to agree and file market appraisals for the former matrimonial home, property particulars, and indicative material on borrowing capacity. That requirement continues throughout proceedings. Once we get to the FDR and final hearing, you're also required to agree and file a neutral composite chronology. The main focus is the court is sick and tired, and indeed in the efficiency statement itself, it expressly says it's unacceptable for the court to be faced with competing asset schedules. Whilst asset schedules are individually identified as being the main offenders, and those of us in practice will no doubt know the pain of trying to read somebody else's asset schedule when it doesn't follow your own structure, one can see why, but it seems to be the case that collaboration is required on all of these documents at all stages of proceedings. I've already talked front loading to death, although the fact that it's required should come as no surprise to anybody, and indeed it's one of the key words, if you like, of the efficiency statement. And then finally, sanctions for failure to comply, which is a rather ham-fisted attempt at foreshadowing one of the next sections of this talk. So then, starting with the ES1, well, what is it? It's a neutral composite case summary. Allows both parties to put their case and is a quick reference point for the court and for counsel. I can tell you from my personal experience that these documents are an absolute lifesaver for me as counsel. If I'm provided with an ES1 and ES2, both of which have been thought through and properly filled out by both sides, it significantly decreases the amount of effort that's required in even pre-preparation in setting up your own schedule of assets. The same is true of the court. It provides a very easy, quick reference, both of these documents, for exactly what is an issue and why. So let's look at it. So this is the first page. I've split it into 2 parts rather. And we can see it's a very straightforward document. The first box, if you like, has all the usual things that you'd require, standard case name, etc. Date of cohabitation, and the authors of the ES1 have even put in helpful square brackets what you need to do. So if you dispute cohabitation, put 2 dates in. Best practice in my in my view, is to put, W says X, H says Y, date of marriage, date of separation, duration of the marriage, and of course the 2 periods are required in all of those if you disagree. Same follows for dates of other hearings. Now, of course, the ES1 is utilised at all stages of proceedings. So if you're doing this at an FDA, for example, you of course won't have the date of the FDR. You can obviously fill that in accordingly. Now, the parties section is a part of the ES1 that's still there's still some trouble in how certain parties approach filling it out, and that really comes down to the net income position. It's important to note that this is net income. It isn't helped, I have to say, by the fact that in the ES2, which we'll look at shortly, there is a when you come to consider income, there is a gross/net option. So you can either put in the ES2 whether the income is gross or net, whereas the ES1 specifically requires net income. It's important that those two marry up, just for the sake of avoiding confusion. But again, a very simple and some may say effective method of simply adding an asterisk if that income is disputed. It's a simple point to make. You don't need to go any farther than that. And at that stage, judges should be aware if net income is placed down with an asterisk beside it, it is an issue. And indeed, that will become clear from deeper analysis of the ES2. Importantly, I'll skip through some of the rest of those points, but looking at open offers, there is now specifically reference to open offers, which reflects Mostyn's costs judgments and the new rules in Practice Direction 28. Page 2, you can see quick legal cost estimates, and what is arguably one of the most useful boxes for the judiciary, which is the issues in the case. Simple 3 selection of choices as to what the issues are. Very, very easy to identify. And of course, there is the unsure response if required. Orders sought and other material information follow. You'll note from both of these pages, and indeed the intention from those higher up in the judiciary, is that the way these forms are to be completed is that the applicant fills in their side, they send it to the respondent fills in their side. This isn't a document that only one party should complete, and it's not a document that each party should provide 2 separate versions of. It enables both parties to put their case on the one document. I hope it will be becoming clear why I've made those references to Robocop at the start, because after that excitement, it all quite swiftly goes downhill as we're talking about forms and efficiency. Right, the ES2, this again, composite schedule of assets. Both parties put their case, quick reference point. I've addressed that for the ES2 above, and as I have with the unacceptableness of competing schedules. Now, what we have on this page, I have shamelessly lifted from the FRC advisory notice from the 1st of February 2022. This notice was released about a month or so after the efficiency statement was released. This sample ES2 was produced by the FLBA Money Subcommittee and was endorsed by Mr. Justice Mostyn and His Honour Judge Hess. So this is an exceptionally helpful document. The updated, the advisory notice is only 6 pages long, can be found on the judiciary website. I appreciate for some of you that the numbers might be a little bit small in terms of both the numbers and the comments to the right. Now, what I'm hoping is that you'll be able to see some of the issues, just addressing in part some of the footnotes here. I don't know if you can see this, but in this example, the applicant says the value of their interest, and this is the husband's interest, is 200, about 55 grand. The respondent's 127.5. The reason for that is it's a property in which there's no dispute over value. We can see there's the same value there, but there's a dispute over to the extent of the husband's beneficial interest. So you can see that it's all the figures remain the same, save for the final line, which is the disputed line. Now, the guidance is when you dispute a figure on the ES2, you should highlight the lines, as we can see has happened here. The applicant respondents say there are different figures that should be attributed to the husband, and therefore there is a highlighted section. Again, and that's one thing that is very rarely done at the moment. When there are disputes as to figures in the ES2, very rarely do we see the highlighted sections, but this is best practice as endorsed by the FLBA and Mostyn and Hess. You'll note as well as we proceed through this, what's particularly notable from the ES2, again, it's a composite document. We've got husband, wife, joint, and each party's case separated into two. Again, this is a document, only one of which should be created. Both parties should be contributing to it. And it's a document that works best when passed between solicitors, really at the stage of whether there's updating disclosure. So I'll take one more example in which, let's have a look at this one. So this is the third document. This one is said to be the wife's. You see on the one hand, the respondent says that she has an interest, pardon me, of 285,000 in it. The other side's left that blank. The reason for that is there is a dispute over the beneficial interest in the property, whether there is any value in it whatsoever. Hence, one side is blank, the other is populated. I should say in your own time, it's really useful to go through this sample ES2 in some detail. It's one thing going through it in a talk like this, which I appreciate can be very dry, but it's quite another to spend your own time reading through it and understanding how it works. So some other examples. Here we have business interests. Again, we see the highlighted sections identify where there's a dispute over the value. This is a dispute over whether or not the shares have value whatsoever. One says 100,000, one says nil. And by virtue of that, there's also a dispute on CGT that we can see. So quite simple. If there's a dispute over something, one side puts that figure in their side of the column, the other puts whatever figure they assert in their side of the column. It is that simple. Right, other guidance then. What else has come out in the efficiency statement? Well, I can't talk about it all in the 5 minutes remaining of my time, but just to canter through it, there is a prescribed length for position statements. That is position statements, notes, skeleton arguments, however you want to, whatever you want to call them. For the FDA, they should be no longer than 6 pages. Interim applications no longer than 8. FDR no longer than 12. Final hearing no longer than 15 pages. And that's with the proviso that there is 1.5 line spacing and 12-point font. It should be said, these limits are best practice, but the backstop page limit, it's still as outlined in practice direction 27A. So we are where we are with that. The efficiency statement says one thing, the practice direction says another, but the efficiency statement goes on to say, if you exceed those limits, be prepared to explain yourself to the court. Witness statements. Pardon me. Witness statements are becoming increasingly highly scrutinised by the judiciary at this time. There is specific reference to the President's memorandum on witness statements, which was released on the 10th of November 21. And the requirement is, well, they go into some detail into it, but to cut it short, it can only contain evidence, can't argue the case, can't use rhetoric, can't express opinions, can't make assertions as to the meaning of documents, can't engage in any prejudicial matters, and must be limited in accordance with the efficiency statement, no more than 15 pages, again, 1.5 spacing and 12-point font, though the 25-page limit, as in Practice Direction 27A, still holds true. It's particularly with respect to witness statements that the judiciary are cracking down now, and we'll see that over the next page with the case of WC and HC. Drafting orders. This is a point that is giving some concern to practitioners, particularly when one considers other time limits that are set down. But they must be agreed and filed on the day of the hearing, unless wholly impracticable, in which case the order must be filed within 2 days, 2 working days of the hearing. We raise an eyebrow as counsel with this because, of course, when you're having to prepare position statements in line with the other aspects of the efficiency statement, whilst also drafting orders, and I think we all know with a wry smile on our faces what it's like once you've got an agreement and then try to hash out the minutiae of the order. So query whether this is truly doable in practice. And then well-being, which I've put in sardonic quotation marks. The position is the without wanting to sound too controversial, the lip service that has frequently been paid to talk of well-being at the family bar by the President and other senior judiciary. In this context, they talk about not expecting late emails to be responded to and early emails the same, and that sending emails between these times is strongly discouraged. I think we all know the nature of the job is such that it is arguably systemically impossible to maintain excellent well-being throughout, despite the assertions from the senior judiciary. But time will tell how well-being improves. And consequences of failure to comply, foreshadowing from earlier, there are now, there will arguably be cost penalties, particularly in respect of failure to comply with the requirements for witness statements. Just to jump slightly ahead, you can see in WC and HC, in Mr. Justice Peel's judgment, paragraph 1, indicating the primacy of importance of this issue. Several issues were raised in this case to do with the wife's witness statement, which had breached the efficiency statement and practice direction requirements by not using 1.5 line spacing, decreasing the size of the margins to the extent that she got 33% more space to essentially moan about the husband and insert various prejudicial issues into the case. Mr. Justice Peel was very unhappy with this and made that position very, very clear. No cost penalties in that case on the basis of various reasons, but nevertheless, it seems more likely in the future. But perhaps most concerningly of all for practitioners is if you fail to comply with the requirements to either provide agreed schedules of assets and chronologies, not exceeding the prescribed length of position statements, or filing position statements outside the subscribed times, the court may indeed make an order disallowing a proportion of the fees incurred in drafting those documents. I'm not aware yet of any decisions that have done so, but there is certainly a sword of Damocles in there. I appreciate I'm rolling over very slightly, so I'll tie this up, I hope. Has it rolled out successfully? Well, it's only been out for a few months. There are still some teething problems, but what we can say is, generally speaking, it's been well received. There are some concerns over the time pressures and consequent penalties if you fail to comply with those. We'll see how that rolls out, particularly now as the judiciary are taking more and more watchful eye over parties' compliance with the efficiency statement. And there we have it. That's it. That was my attempt to make efficiency interesting. I'm sure I've failed miserably, but I'll be happy to answer any questions, of which I can see there are a few in the chat. And we'll now pass over to the capable hands of Mr. Pentony.
That's very kind, Luke. Thank you, and well done for battling through COVID there to present to us this morning. So thank you. Let me just see if I can bring up my screen here. Hopefully everyone can see my slides. If you can't, please let me know quickly so I can deal with that. So, enforcement of financial remedies orders. Well, I think the first thing to say is that these sorts of applications are clearly a deep source of frustration and upset for clients for obvious reasons. But I'm proposing to deal with this within the space of hopefully about 15 minutes in 4 parts. The first thing I'm going to talk about is any necessary permission that needs to be sought. I'll then go on to talk about general principles in 2 parts, really. Then deal with costs and interest, and very briefly, I have to say, talk about Hadkinson orders. The reason I say that is there are clear limitations with the time of this presentation, because probably each of these topics could be dealt with in a separate presentation. So 1, limitation needs to be considered, but practitioners will be aware that the 6-year limitation period on new actions doesn't apply in enforcement proceedings for financial remedies. It's not a new action in effect on a judgment. That's certainly in most cases. In respect of unpaid maintenance pending suit, interim maintenance and financial provision, if that's due more than 12 months before proceedings, permission will be needed, and you can make that application in form D11, and that should be made separately to the substantive application. So moving on to general principles, you'll find effectively the CPR imported into part 33 of the Family Procedure Rules. And 33.2, which imports part 70 of the CPR, sets out effectively the mechanisms of enforcement, whether that's a writ of control, third-party debt order, attachment to earnings, and so on. And I'll deal with which of those can be done without notice in effect to the respondent a little bit later on. And obviously that will need careful consideration when thinking practically about these sorts of applications. The other thing to note is in regard to recitals. If a recital is made in terms of an enforceable order, then it will be enforceable. It's not in my slide, but the converse also applies. But the case law would suggest in BSA and MBT, as I've put up on the slide there, that it's unlikely that parties would come to an agreement that they wouldn't consider to be legally enforceable. So I think that's certainly a point to take into account when considering the drafting of orders. An application notice can either specify the mechanism of enforcement sought, or it can be effectively left to the court. From my own experience, I have to say that where a respondent is directed to attend court and be questioned under oath in situations like that, it is worth checking the listing on a purely practical level, because technically speaking, these hearings are to be dealt with in two parts. The first is the questioning, and the second part will be the hearing. In reality, I've seen a variety of ways that that's been dealt with across the country, and can typically be rolled up into one hearing. There can be separate listings, so it's certainly worth making sure that you know how that part of the application is going to be listed, because I've certainly been in a situation myself where it's forced an adjournment of the application. Some practical points. The application for enforcement's got to be accompanied by a statement setting out reasons, and any available mechanism that I've discussed can be used. They can also be used together. It doesn't necessarily need to be just one method of enforcement. And if a particular method of enforcement is sought, then it should be done so under the applicable rule. And I set those out here for convenience. I'm not going to go through each of those. There's no point. You can all read, of course, and those slides will be sent around afterwards, after the event. Just moving on briefly to costs, that's dealt with under Civil Procedure Rules 45.8. It's fixed costs for legal representation. Where the application is a general application, meaning that you haven't specified the mechanism of enforcement, costs are dealt with in accordance with the schedule under the CPR, which is at 45.8, and that is mechanism dependent in effect. In respect of interest, that accrues automatically from the date of payment, and there's a separate discretionary interest component where payment is being deferred. So where the court has made an order, in effect, that the payment's deferred. And any interest claimed, I go back to the statement point that I made earlier, that needs to be set out clearly in a statement, and how that is being calculated. That needs to be clear. Practitioners will be aware that there's no interest payable on a lump sum in family proceedings under £5,000. I'm going to talk very briefly about Hadkinson orders, which there has been recent case law on, and I set that out below. It's a remedy of last resort. It can be made at any stage in proceedings where there are persistent breaches of orders, and it prevents, in effect, the breaching party from seeking a further legal remedy. But they are draconian, considered draconian. And there's a helpful summary set out in Day Forward, I hope I've got that right, which is the 2018 case I've set out there, which neatly summarizes the principles that are to be applied. So hopefully you've got the full reference there. The other case, of course, is Mubarak and Mubarak, which deals with MPS, always amounting to a contempt in enforcement proceedings. So that's key for those of you who have to deal with those sorts of applications in your daily practice. I'm not sure how long. I did say that would be whistle stop. And I think it has been relatively whistle stop. So there's probably some time for questions now, I suspect. And I know that there have been some questions put in the chat box and the Q&A box. I don't know whether, Luke, if I stop sharing my screen, perhaps we can start dealing with a few of the questions that have been posed.
Yes, thank you, Sam, and thanks very much for that that talk. You're quite right; it is always a bit of a pain, isn't it, to enforce in FR proceedings. Yes, so we've got quite a few questions to get through. I'm quite keen. I've been trying to work through the ones that I can easily answer typed. So do have a look. Those of you who've asked some questions, I've answered some in the chat box. I'll try to get through as many as possible. But first, just to shout out, we've got Deputy District Judge Melville Walker, who has very kindly given us a judicial tip for the breakdown of the ES2, and that is, instead of leaving the column blank, put a 0 instead. I have to say I completely agree with that, and I believe somebody else whose question I can't find at the moment suggests that they prefer to insert all the figures, but when it comes to writing the interest, typing a 0. I also endorse that approach. I think it makes it clearer, in my view, that the parties are actually engaging with that side of the ES2. And that's, I think, really important, because often if you see something's blank, you think it leaves you to query, doesn't it, whether or not someone's actively filling in the schedule or not. And that, of course, does away with that. And as we're hearing it from the judicial horse's mouth, as it were, and no offence at all intended to Judge Melville Walker. But yes, that's a very, very good point. Now, I've become a bit of thanks for that, Derek. I've become a bit of a nerd about the efficiency statement, and I'm conscious that Sam is giving this talk as well. So I think perhaps if we, for the time being, switch between questions. So Sam, did you want to answer? Are there any questions that jump out to you you'd like to answer about the about enforcement?
I can't see that there are that many at the moment. I'm actually just going through the questions.
Right. Well, in that case, I'm quite happy to continue to bulldoze my way through the questions with no remorse. Very well. Well, a lot of you were asking whether or not there's still a requirement for statements of issues. That point has gone fairly unaddressed in the efficiency statement. On the one hand, you could argue that the ES1 specifically has the issue section, i.e. unmatched contributions, conduct, etc. That gives the judge a very good insight as to the statement. However, if there are issues that are a little bit more discrete, or you think that it's going to be, well, to assist the court to outline a brief statement of issues, and I'd say, and again, not having any judicial experience, but my understanding is judges, less is more is the better approach. So if you can keep a statement of issues to 1 or 2 pages, then it can't hurt where appropriate. So hopefully that clears that up. In terms of chronologies, the court expects agreed composite chronologies where appropriate. Not for the FDA, but once you get to FDR, or if you're using the FDA as an FDR, then that's the point. That's the point to do it. Sam, feel free to cut me off at any time, but I'm just going to.
I'm just plowing through the questions. There are quite a few of them, so I'll jump in when I've had one.
Okay. So, what else do we have? We've got one from our very own Antonida, who asks essentially what we do with disputed figures, whether they'll still need to be competing schedules. There should just be one schedule. Somebody else asked a question in which they talk about there are 3 columns for the ES2 now: husband, wife, joint. And in those 3 columns, there's applicant's case, respondent's case. The way one addresses, fills out the ES2 is this. You say you're the applicant, you fill out what you say the husband's resources are in your side of the column. Then once you finish the husband's column, you move to the wife's column, you put your case for the wife in your side of that column, and joint assets, which is often, the FMH, in the simplest cases, you put what your figures are in your side of that column. That should be done for every aspect of it. There should only ever be one ES2. There's some room to the right of the schedule to insert notes. That can sometimes be helpful for a judge, because if you've got a dispute, it can help just to explain briefly why that figure is disputed. Again, so it's a single point of reference. Really useful to look at the update, the advisory notice of 1st of February. But also, and this is my second shameless self-promotion, but in the June edition of the Family Law Journal, I've done an article updating article about the FRC Efficiency Statement, in which I've included various tables in a Q&A format as to how best to approach some of the more frequently experienced issues. Another question that's been raised by various people, well, there are two seem to stand out. The first relates to Form H. The second relates to litigants in person. And sorry, I smile when I think about trying to agree schedules with litigants in person. Form H is still required. It's a pet. Well, it's not a pet hate, but it's an issue that is arising frequently, is that Forms H's aren't matching the asserted costs in the ES1. It's really important, particularly if you're arguing a needs case in which part of the capital award needs to be paid towards legal fees. It's really important that those are accurate. I had a case where I had to ask the other side's fee earner to provide me with some evidence because there was a discrepancy between the ES1 and the Form H provided. So it's really important that they match where appropriate. So yes, Forms H is very, very much still required. As for litigants in person, my heart aches for those of you dealing with litigants in person who through no fault of their own, being lay people, struggle to trust us lawyers and engage in things as the president assists. I can't give any real tips as to how to deal with them, because each person is different. But dealing with individuals, that is. But if you're trying to fill out these forms and get the input of a litigant in person, first point is, pardon me, you try to get there, try to explain to them as concisely as possible. There's a input your figures in this column and what you say in this column, please. And if they simply don't do that, you've got to try and do the best you can. It's a rubbish answer, I know, but I think the court, of course, gives wiggle room to litigants in person. And if you're against a litigant in person, if you're doing everything you can to assist the court and you're not being helped by by the litigant in person, I think it very unlikely you're going to be penalised for not complying exactly with the rules. Sam, I see you're unmuted.
Yeah, just there's a couple of questions, I think, about interest payable on sums of £5,000. If it's less than £5,000. The simple answer is that no interest is payable in the family court on an outstanding lump sum if it's less than £5,000. And that's subject to section 23(6) of the Matrimonial Causes Act. So I can refer you to that. Above that sum, it automatically accrues, is the answer to that. I hope that answers the question.
Thanks, Sam. A couple of questions have come out about the FDA. I believe Derek Parsons has asked whether there's any point in it at all, given the front loading. I think there's certainly the judiciary are pushing to reduce hearings. And one way is you do that if you front load it and you see it's a fairly simple case, then you settle it at FDA. I was before His Honour Judge Hess a few weeks ago, and he rather forcefully requested that we made our FDA and FDR, which caused my opponents and I no small amount of hassle. But it does depend. If you've got sometimes FDAs are essential. If you've got issues over valuations, if you've got property portfolios, if there are questions outstanding about business assets or beneficial interests, very, very important to get the appropriate directions. In some cases, save for the fairly simple and straightforward, in which the parties agree what principles apply, FDAs will still be required, nevertheless. Now I'm just having a look through, see if there's any questions I've missed.
I can see there's also a question about permission, which I said earlier should be made on a D11. There is actually no prescriptive, unless Luke corrects me, there's no prescriptive way, I don't believe, in the FPR for permission applications. They can even be made informally. So it may be advisable to simply to issue that application, to issue the application for permission, would be my view. I don't know what you think, Luke.
Yeah, I think where at all possible, try to do it as in accordance with procedure as much as you can. I believe it would be part 18 for permission. So pop in your part 18 application just to cover your bases. Question from Arzu Loan, again, and this is on the issue of litigants in person. If one party's in person, is a solicitor expected to complete both sides of ES1 and ES2 based on the information available? No, I think is the short answer. That's as short as that answer can be. It's ultimately, if the other side is being uncooperative, then really when you put the ES2 before the judge, you say, well, look, we've tried. The only person, we're the only ones who's complied with the requirements of the efficiency statement. If you've got a ballsy barrister, they may even try and argue, well, the other side should be bound to the computations that you've proposed because you've carried out the procedural requirements. You might get short shrift from a judge, but I would probably try that if I was representing you in that particular case. No doubt there'll be some quite interesting procedural points you can make in certain cases if the other side isn't complying. And that's the other thing that you need to be aware of. It only works if both sides work it. Yes.
I can see quite a specific question, which I can really only talk generally about, I suspect. which is whether a D11 needs to be issued on part of an outstanding sum. Of course, I perhaps didn't say actually that you can enforce part or all of the financial remedies order. It doesn't need to be the whole order, but also the D11 that I mentioned is for permission, where permission application, where an application for permission is required, not the substantive application itself. But that can be taken offline if anyone wants a chat with me.
Thank you, Sam. Alice Taylor, I hope I'm saying that right. Don't worry at all, not a ridiculous question. ES1 and ES2, yes, they do need to be done prior to basically every hearing. I think in one of the questions I answered while Sam was talking was what you do in sort of interim hearings. Pardon me. And that will depend, but for all the big three hearings, your FDA, your FDR, your final hearing, ES1 and ES2 should be produced in all of those hearings. Once you get to FDR, the final hearing, agreed composite chronology also needs to be added into the mix, along with your usual property particulars and mortgage raising capacities. It's one of those things. I'm such a nerd for this now. I'm quite full on with the efficiency statement. So if anyone has any specific queries, or indeed if I ever am instructed, I tend to, one of the first things I tend to do, people are probably getting quite sick of it by now, is send my instructing solicitors an email reminding them of the efficiency statement and making sure everything's sorted.
I'll certainly be adopting that practice, Luke, so that'll include me as well.
Okay, well, I won't be the only one annoying solicitors then. That's good to know. Page limit for witness statements, does that include exhibits or just narrative? That's an interesting question. I believe that's just narrative. You don't quote me on that, but I understand that's just narrative, because of course if you're appending bank statements to a witness statement, then of course you can't be limited to 25 pages. But that's practice direction 27 you'll want to have a look at there. I think it's paragraph 5.2a, big A, which tells you a bit about page numbers. And just to say, if there are any other barristers listening, when we're talking about page limits for position statements, page limits include any of your own net effect schedules already. Just because the ES2 has to be the only sort of composite asset schedule doesn't mean that counsel aren't still allowed to use their own documents to illustrate certain outcomes. For example, most commonly used net effect schedules. But be aware that will eat into your page limit. So I've started to do little tables rather than big long columns. Well, my goodness, I feel like I've talked efficiency until I am blue in the face. I think that does it for all the questions, or the majority of them anyway. And therefore, Sam, unless I've missed anything, I think I can send everyone comfortably on their way.
I think we'll be in trouble with our marketing team if we don't mention that the next brunch seminar is on the 30th of June. Well, I think Delphine's just put that in the chat box as well.
Oh, good. Yes, we don't want to face the wrath of Delphine. No, yes, quite right. Well, thank you all for coming. It's been a real pleasure speaking to you all. As Sam says, next seminar is the 30th of June, which is a Thursday, I believe. And Delphine, I believe, has sent a pre-registration link in the chat box. So feel free to pre-register at your leisure. Thank you all very, very much. And thank you for your kind comments and questions. And as always, if we can assist on any specific matters, please don't hesitate to get in touch. Thank you all.
Thank you.